Live.
Hello and welcome to the Regulatory Transparency Project's webinar, a discussion on the Biden administration's new Title IX regulations. My name is Steve Schaefer, and I'm the director of the Federalist Society's Regulatory Transparency Project. Today, we are excited to have a stellar panel of experts. To find out more information about all of our esteemed panelists, please check out fedsoc.org. That is fedsoc.org. Note, all expressions of opinion are those of the panelists. During our program, if you have any questions, please submit those questions through the Q&A function. Happy to introduce our moderator today, Robert S. Eitel. He is the co-founder and president of Defensive Freedom Institute for Policy Studies, also known as DFI. He previously served as senior counselor to Secretary of Education Betsy DeVos from 2017 through 2020, and previously as deputy general counsel of the U.S. Department of Education from 2005 until 2009. Bob, over to you.
Thank you, Steve. I'm delighted to be here, and I am so pleased to be with three friends and former colleagues, Kim Richey, Will Trachman, and Corrigan, for a discussion on the Biden administration's new Title IX regulations that were formally published on April 29th of this year. And I can't think of three better people to talk about this. They all have experience not only in the Department of Education, but also in state government, school districts, litigating on behalf of the public interest. Kim is currently serving as Senior Chancellor in the Florida Department of Education. She most recently served as Deputy Superintendent at the Virginia Department of Education. She's served in multiple capacities at the U.S. Department of Education, most recently as acting Assistant Secretary and Principal Deputy Assistant Secretary in the Office for Civil Rights during the Trump administration. I might add that she also has served as General Counsel of the Oklahoma Department of Education, and interestingly and importantly, is a certified teacher as well. Will currently serves as General Counsel for Mountain States Legal Foundation. Prior to that, he was a colleague of ours as Deputy Assistant Secretary in the Office for Civil Rights at the U.S. Department of Education. And prior to that appointment, Will was the General Counsel to the Douglas County School District in Colorado. Christian currently serves as the Solicitor General of Montana and has been with the Office of the Montana Attorney General since 2021. He previously served as Senior Counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education under Secretary DeVos, and was an attorney in public interest litigation law firms prior to coming to the department. So before we get into questions, friends, I'd like to set the table a little bit for those who have not been following the Title IX issue closely. And I think it's important to clarify that there's a number of rules in play. There's the current rule, which Secretary DeVos published in 2020. So you may hear references to the DeVos rule or the 2020 rule in this conversation. There is a rule published by the Biden administration on April 29th, 2024, which is a complete overhaul of the 2020 regulations and more, which is the focus of this discussion. And then there's a third regulation, a proposed regulation, which is focused on athletics in Title IX, which we may refer to as the Athletics NPRM or the Coming Athletics Rule. That rule has not yet been published. So let's get into the conversation. I can't think of an education issue that has created more controversy than the recently published Title IX regulation. We've had pushback from states. We've had declarations from governors and state superintendents who have indicated they will refuse to abide by the regulations. There are already a slew of lawsuits filed to stop or enjoin the regulations. Why the pushback? Kim, I'll start with you. What does this rule do in connection with Title IX that has people in such an ire?
Yeah, thank you so much for the question, Bob. And it's so good to be here with you, Christian and Will, today. Thank you for the opportunity. So, I think that one of the most significant changes and one of the reasons why this rule is causing such an uproar within, not just the education community, but across the country has to do with the rules expansion in several different areas, but more specifically, the expansion to specifically include gender identity and sexual orientation. So, of course, Title IX prohibits discrimination on the basis of sex. And what the Biden administration has done, although it's not surprising, is that they have expanded the scope of Title IX so that discrimination on the basis of sex specifically includes gender identity and sexual orientation. Now, I want to kind of focus on two provisions of the rule that I think are pertinent to this particular discussion. The first is 106.10, which deals with the scope and application of the new regulations. What the rule says is that discrimination on the basis of sex includes sex stereotypes, sex characteristics, pregnancy and related conditions, sexual orientation, and gender identity. So at the outset, with regard to the scope of the full rule, there is a categorical inclusion of sexual orientation and gender identity without the department actually defining those terms. What it means is that all forms of sex-based harassment prohibited by the rule as sex discrimination are going to be applicable to students and employees based on sexual orientation and gender identity. So in addition to that, in addition to broadening the scope of the entire rule, the department has at least partially eliminated longstanding provisions of Title IX that have allowed schools to separate students on the basis of sex. Now, for decades since its passage, Title IX has allowed schools to separate students on the basis of sex, as long as that separation was comparable or equal. That's why schools have been allowed to have separate facilities for restrooms and locker rooms. It's why they've been able to offer separate athletic teams. A new section of the Biden administration's rule, 106.31 A2, for those who are interested in looking up, specifically pertains to the different treatment of students and the separation of sexes. And what it says is, in those situations where separation is permitted by Title IX, a school cannot subject a person to more than de minimis harm. So a school cannot have a policy or practice that that separates if it's going to cause more than de minimis harm. Now, it's important to note that the rule does include exceptions to this. So the rule has identified specific exceptions where the no de minimis harm rule does not apply, based on the reasoning that Congress statutorily approved of the sex separation, even if it did cause de minimis harm. So there are three specific citations, which are exceptions to this no de minimis harm rule. The first is 20 USC 1681, which provides for exceptions, but also exceptions to sex separation, but also general exceptions to Title IX in general. So it allows for religiously affiliated institutions to be able to not have to comply with Title IX if there are certain parts of the rule that are contrary to their religious tenets. It allows for institutions who train for military service or merchant marines to be exempted from the requirements of the rule. It allows for fraternities and sororities and voluntary youth organizations, father and son and mother and daughter activities. So what the department is saying is all of these activities can continue because there is a congressional exception, and Congress has said that even if that separation causes de minimis harm, they are still permitted by Congress. The second bucket is 20 USC 1686, which is a specific exemption for living facilities or sex separate housing. So those facilities are exempted from this no de minimis harm rule. And then the third exception deals with sex separate athletic teams. Now, interestingly enough, this is not a statutory citation. What the department has done here with this third exemption is they are citing to a regulatory citation that has allowed for decades schools to continue to offer sex-separate athletic teams. Now, this is not a statutory citation, as I mentioned, but the department is allowing it because the department back in 1975 submitted the athletics rule to Congress. Congress had 45 days to disapprove it, and Congress did not disapprove it. And so they are looking at that congressional inaction as Congress's stamp of approval that sex-separate athletic teams are permitted, even if they do cause de minimis harm. So the bottom line is that in those areas where Congress has authorized separation or differentiation between the sexes, the no de minimis harm rule that the department or the Biden administration has established will not apply. Now, interestingly enough, the department goes on to say that a failure to allow an individual to participate consistent with their gender identity causes more than de minimis harm or subjects that individual to more than de minimis harm. So the department has included a categorical statement that anytime you do not allow an individual to participate consistent with their gender identity, you have caused more than de minimis harm, and you are in violation of the rule. So what this looks like in practice and what this is going to look like for schools is that schools can separate based on sex. They can differentiate based on sex, but they can't cause more than de minimis harm. They have accepted certain situations where the de minimis harm rule does not apply. So, except where Congress has specifically allowed. But they have also stated that preventing individuals from participating consistent with their gender identity causes more than de minimis harm. So the next obvious question is what's left, right? If the department has created statutory and regulatory exceptions to this rule or exemptions, what's left? And unfortunately, under the final rule, there are certain intimate facilities that are not included in those exceptions. And that's why you're hearing the outcry from folks across the country. So what this means is there is no exception for locker rooms and there is no exception for restrooms. So a school's failure to allow an individual to participate consistent with their gender identity in accessing both locker rooms and restrooms will be considered to be subjecting that individual to more than de minimis harm, and it would violate Title IX. Now, not surprisingly, the department makes a point to note that even with these exceptions, there's nothing that prohibits a school from voluntarily allowing students to participate consistent with their gender identity. I thought it was really interesting that they made that point. The other thing that I want to point out is they made sure to emphasize that individuals who are transgender, who might have gender dysphoria, that those individuals might be served under Section 504 of the Rehabilitation Act. So they made sure to point out that transgender individuals might have protections under Title IX and also might have protections under Section 504 as students with disabilities. So I think across the board, what you're seeing is just is really just an expansion of every aspect of this Title IX rule. It's important to note that specifically with regard to sexual orientation and gender identity, the impact of including sexual orientation and gender identity in the Title IX rule is truly going to be impactful for students and I think for employees as well and for schools.
School districts, yeah.
The reason why is because schools are now under the new rule required to address conduct that simply contributes to a hostile work environment or a hostile environment at school. So even if that conduct occurred outside of the United States, even if it occurred outside of the education program and activity, a school is still going to be required under the new rule to address that. So at the same time, we're adding protections and we're pulling in sexual orientation and gender identity into the rule, we're expanding the jurisdiction. We are saying that, conduct that occurs outside of the United States or conduct that occurs outside of an education program in activity is all going to be covered to the rule. And I think the obvious question here and the result is that more conduct, additional speech, there's a lot more activity that is going to fall under the broader jurisdiction of Title IX. And that is certainly going to have not only implications with regard to conduct, but particularly implications with regard to speech. The department emphasizes that nothing in the rule conflicts with the First Amendment. But what the department said is they essentially did not weigh in on whether verbal conduct could constitute sex-based harassment. The closest they got was saying that a single remark or misuse of language would not constitute harassment under Title IX. But they have left open this idea of whether not abiding by someone's pronouns would be misgendering. And we know from their recent enforcement that they have held schools in violation of Title IX for allowing the misgendering of students. So I think the biggest concern and why people are reacting is just because of this categorical expansion in all aspects of Title IX, except due process.
So I have to ask you, what is the legal basis for the expansion in scope?
Yeah, so I think that the legal basis is certainly Bostock. I think that the department relies on a case that was determined by the Supreme Court in 2021. The name of the case was Bostock versus Clayton County. And it essentially was 3 consolidated cases that were considered by the Supreme Court. And the court narrowly ruled that the prohibition against sex discrimination under Title VII of the Civil Rights Act protected employees from termination on the basis of gender identity and sexual orientation. And very early on, the Biden administration gave signs that they were going to reverse Trump era determinations, that Bostock would not apply to all areas of Title IX. And, there were a lot of comments that were submitted to the department specifically focused on Bostock. And everything from, there were different meanings of sex at the time of the adoption. Commenters pointed to the differences between Title VII and Title IX. Commenters pointed to the differences between the education environment and the employment environment. They emphasized that fact, exactly what I was discussing earlier, that Title IX allows for separation, that it allows for differentiation. But obviously, the department did not find any of these arguments persuasive. They specifically noted that, or they ignored the fact that the Bostock court specifically declined to expand their ruling to other federal laws. They pointed out that it was specific to Title IX.
Yeah.
They ignored that the issue was very narrowly framed, and they really ignored that Bostock referred to biological distinctions. So they ignored that it wasn't because of sex, didn't really mean biological sex. It was that the employer treated employees differently as compared to others of the same biological sex. And their main argument is that the addition of sexual orientation and gender identity is necessary to effectuate the purpose of Title IX. They argue that it results in greater protections, and they argue that it is consistent with Title IX's purpose to expand Title IX in this way. They just did not adequately respond, I think, to a lot of the legal arguments that were raised through public comment.
Thanks. We could spend easily an hour just talking about the gender identity provisions and application of Bostock and how all that went down in the preamble. I would like to shift gears slightly, given that we have a limited amount of time, and turn to you, Will, to talk a little bit about how the new rule deals with the definition of sex-based harassment, with reference perhaps to the DeVos rule, as well as the institutional response required by an educational institution, the role of the Title IX coordinator, all of that stuff.
Well, thanks, Bob. It's great to be here. And thanks to Kim and Christian for being co-panelists. It's an honor to get the band back together. Let me take a step back. 1972, President Richard Nixon signs Title IX into law. as part of the education amendments of that year. And you could put Title IX into a nice manila folder. You know, it's, as Kim said, it's at 20 USC 1681, and it says you can't discriminate based on sex if you receive federal funds. It has a few exceptions, a few other provisos, but for the most part, it's not that long. You could read it today if you wanted to. And the rest of what we're talking about comes from either guidance documents or regulations. So Bob's referred to the 2020 rule, which is currently in effect and may continue to be in effect going into the future, depending on the litigation. The final rule that is not effective yet till August. But over the years, the question became, well, what does Title IX cover? And as the Supreme Court announced that Title VII, which bars sex discrimination in employment, as Kim referred to, covers sex-based sexual harassment, that the same type of protections applied on campus under Title IX, which is comparable in terms of what it prohibits. Well, then it became an issue of, well, okay, if there's a protection against sexual harassment, what processes have to happen and what counts as sexual harassment? And so in the waning days of the Clinton administration, a long guidance document addressing some of those questions was issued, really, I mean, in the last day or two of the Clinton administration. That document, for the most part, survived the Bush administration. And then in 2011, and then again in 2014, the Obama administration changed the playing field. They made it so that most investigations and resolutions of allegations of sexual harassment had to be resolved within 60 days. They discouraged cross-examination rights as potentially re-traumatizing victims. They didn't specify what sort of evidentiary duties schools had in order to make the process fair to the accused student, who obviously suffers the risk of being suspended, being expelled, having the transcript notated, loss of future income. And so all of these things triggered complaints over how much process or how little process really campuses were giving to students who were accused of sexual harassment. You know, the phrase kangaroo courts is thrown around frequently to describe that Obama era. And so when President Trump took office in January 2017, and then Secretary DeVos shortly thereafter, this was a big deal. The department has regulatory authority to interpret and articulate what Title IX means. So even though it's just a manila folder of statutory citations, the regulations are expansive, and you can find them at 34 CFR Part 106. Secretary DeVos gave a speech in September of 2017 talking about how the kangaroo court system could no longer stand, and we needed to embark on measures to ensure, number one, that we weren't ruling by letter, that is, guidance documents from the Clinton era, guidance documents from the Obama era. We needed to enshrine actual law that went through notice and comment, and that could actually be predictable and reliable across the country. And so that's what happened in 2020. As Bob pointed out, this rule took form. It was effective in August of 2020. And from the get-go, President Biden announced, despite having himself been accused of violent sexual harassment, that this rule was on the chopping block as part of his administration. In fact, in the early days of the Biden presidency, he ordered the Secretary of Education to consider suspending federal law, although it wasn't clear under what authority you would be able to suspend federal law. All that is to say, the rule that was promulgated on April 29th cuts back on due process, makes it so that schools have much more flexibility, harkening back to the 2011 and 2014 era, to ram the process through and to give accused students much less due process before being subjected to discipline for sexual harassment. Specifically, the 2020 rule, which is in effect, requires that the definition of sexual harassment is heightened. It has to be severe, pervasive, and objectively offensive. The new rule says it has to be subjectively and objectively offensive, but only severe or pervasive. And so something that only happens once could count if it's severe enough, or something that's not a trifling, but definitely not all that severe could count because it's pervasive. The Title IX coordinator role, which often led to some of the kangaroo court allegations under the 2020 rule, had to be separated from the person who investigates and the person who makes the decision, meaning that no one can be judge, jury, and executioner of a student who's accused of sexual harassment. The rule that was just promulgated takes away that issue and returns to what's called the single investigator model. So the Title IX coordinators can do it all. They can investigate, they can make decisions. It also removes the right to cross-examination, which was something that the 2020 rule put in place at the post-secondary level. And it requires Title IX coordinators, in addition to responding to allegations of sexual harassment, to go out and look for them, in the sense that they have a duty to look around for barriers to reporting. And if they fail to do that, they can be subjected to federal investigation and a loss of federal funds.
Can I underscore that point? Can I underscore that point? Well, I got to tell you, looking through the provisions that affect the Title IX coordinator role, which has been part of the regulatory scheme for since I think 1975, but nonetheless part of the game for decades. I'm struck that the Title IX coordinator is by these regulations are becoming a Title IX monitor, which is a very different function than coordinator. That there's a monitoring function that's imposed on institutions that didn't necessarily exist before at all.
Right. Well, so a Title IX coordinator always has to be reactive, right? They gather information, the complaints are filed with them, and they have to be responsive to those allegations. Here, initially, the proposed rule said that schools had a duty to respond to sexual harassment, even if they didn't know about it, which really would, be wild. Catherine Lehman, in announcing the
and she is who?
The Assistant Secretary for Civil Rights and who has jurisdiction over enforcing Title IX. Thank you, Bob. She said, well, we changed that because it's not really fair to force schools to have liability for stuff they don't know about. But they kept in this provision that Title IX coordinators have a duty to look around and determine whether there are barriers to reporting or other threats on campus. So you are creating, as I think you're alluding to, a situation where the Title IX coordinator has to go out and find instances, or if they don't, there's some question about whether they've fulfilled their duty to look around or not. Because if they have nothing to report, that's either a result of nothing's going on, or it's a result of their lack of doing what they have to do. And so the Title IX coordinator's incentive is to comply with federal regulations, avoid being investigated, and start finding things around campus that look like sexual harassment to them. So it really is a change toward this ombudsman role. There's also one interesting thing that I only noticed this morning, which is that although they do keep some of the due process protections that are in place currently, they have a provision that says that the school can delay the notice of allegations and the notice of due process rights if it would impair the safety of the complainant, which I think is a loophole that you might be able to drive a truck around or truck through. You have the mental health safety, you have people who allege that their safety is impaired through, words and that they're harmed by that. So I do think there are going to be instances where schools say, yeah, we didn't give notice to the accused student, but that was for the safety of the complainant. There are also some really quirky items in the rule. For instance, the rule defines all stalking as sex-based harassment. So even if, someone's obsessed with the quarterback of the football team and stalks them, but there's no sexual allegation whatsoever, there's no sex-based harassment, the rule nevertheless defines all stalking as sex-based harassment regardless of the circumstances. They also have a weird provision about public events, meaning that if the school learns about things at a public event, say, a Take Back the Night event about campus sexual assault awareness, that the school has to consider those speeches in its Title IX process and complying. So if there's a bunch of speeches about how an area of campus is dangerous, now you have an affirmative duty to go ahead and, based on those speeches, act, which creates a weird game of telephone, of course, if you have some administrators, but not the Title IX coordinator there. If some administrator conveys to the Title IX coordinator, oh, I went to this event, they told me a lot of things, you better act on them. It'll also play out in strange contexts now that the standard for sexual harassment is lower. So the one that occurred to me immediately was the pro-Hamas encampments that are going around the country. Many of those involve denying that rape occurred on October 7th. And so to the extent that someone is offended and denied equal access to their education based on those sex-based statements, the school may have a duty to respond and shut down an encampment related to that, which I'm confident was not something that was going through the minds of the department as they were finalizing this rule. So I can stop there. I mean, I have some comments about what they kept, which is good, and some First Amendment concerns, but I don't want to dominate the discussion.
So we could talk for the entire afternoon about this regulation. Let me ask you this: what are the 3 items regarding due process changes that concern you the most? Speaking as one who's worked on this as a regulator and as a school district attorney.
Yeah, so let me say what I'm not concerned about as much, which is interesting because we get a lot of criticism as we were drafting the rule for saying that the accused is presumed innocent until the end of the process. We got a lot of left-wing groups saying you're basically accusing the person who complained of sexual harassment of lying. That's in this rule, though, in the April 29th rule. We got a lot of criticism about informal resolution, that was not appropriate, that it was going to pressure victims to do informal resolution as opposed to the more robust processes. That remains in this rule. And the right to appeal, which people accuse us of, re-traumatizing a victim by making them go through multiple stages of a process. There's still a right to appeal here. What am I concerned about? Single investigator model, the Title IX coordinator monitor aspect that we talked about, and the reduction in the standard of sexual harassment, all of which I think will lead to more school involvement in everyday life, looking for sexual harassment, and also more federal involvement in regulation.
Yeah, and we could talk about other aspects, such as the mandatory preponderance of the evidence standard in most circumstances, restrictions on access to notice of allegations. One thing that I was just perplexed about in the regulations was they appear to have taken down the requirement that training materials be posted on the website, which Title IX training materials is a requirement of the 2020 rule. They've taken that out, which you can ask for them, but they're no longer required to be posted. I just find that to be odd and perplexing and needless, gratuitous. Christian, as you sit in Helena, Montana, in 4 inches of snow on May 8th, let's talk about some legal concerns that have been raised about the regulations. There's a slew of, and maybe even perhaps make reference to some of the litigation that's been filed.
Sure. Well, thanks, Bob. It's a privilege to be here with my former colleagues and folks that have been in the trenches on these issues since even before I had the privilege of being at the department. So I'll talk a little bit about the legal challenges broadly and a couple of specific things. But as I'm sure many of you guess, one of the big legal arguments against the new Title IX rule that Kim discussed is that it inappropriately incorporates the concept of gender identity into what constitutes discrimination on the basis of sex. And all of the plaintiffs in the lawsuits have said that the Administrative Procedure Act under 5 U.S.C. 706 says that courts shall hold unlawful and set aside agency action that, among other things, is arbitrary, capricious, and not in accordance with law. Now, the administration's response, and Kim spoke about this, is essentially that, well, after the Supreme Court's decision in Bostock and the Title VII case, it's pretty obvious that sex is included in gender identity. And secondarily, even if it is ambiguous, the government gets the latitude to define what constitutes discrimination. And the department has always done that, or at least that's their argument. So then, of course, as lawyers, we put on our tools of statutory construction, and we go to battle over what the word sex means. And I think 2 of the big vulnerabilities that the plaintiffs have pointed out in these cases are under the major questions doctrine and under the Pennhurst doctrine. And I'll discuss both of them here. And I actually think they're related. So what is the major questions doctrine? I'm sure many of you are familiar with that. It's a canon of construction that says federal agencies cannot resolve questions of vast economic and political significance without clear statutory authorization from Congress. In other words, major policy decisions come from the people's elected representatives in Congress, not from federal agencies. So it's functionally a limitation on executive power. Now, how do we know what constitutes a major question? Well, just recently, we had the Biden v. Nebraska decision deciding whether the post 9/11 HEROES Act should let the Department of Education forgive hundreds of billions of dollars in student loans. And it looks back to the first official major questions doctrine case, West Virginia v. EPA, and says we're going to look at a few factors. The first is the history and breadth of the authority the agency had asserted. So courts are going to look at, are you taking an established statute and sort of claiming a new sweeping power? So think about Biden v. Nebraska with student loans, the eviction moratorium case, Alabama Association of Realtors, the OSHA vaccine mandates, and cases like that. We're looking for, as Justice Scalia famously said in the non-delegation doctrine context, trying to fit elephants into mouse holes. And Justice Scalia famously said Congress doesn't do that. So there are lots of merits arguments about why Title IX doesn't contemplate anything other than sex as binary. And I think given the history of Title IX over the last 50 years, the complaints make the case that that's exactly what's happening here. Given the history, text, and structure of Title IX, there's no way that it includes gender identity and sexual orientation. The second category that Biden v. Nebraska said to look at is issues that are of economic and political significance. So let's start with the easy one, political. I mean, I think you would be hard-pressed to find an issue that's generated more political debate, controversy, and attention over the last few years than gender identity, and even more specifically, men playing women's sports and sharing intimate facilities. You have companies like Bud Light losing billions, you have Leah Thomas, and you have laws in nearly every state taking sides on this massive political controversy. So the states have argued and are going to argue that and plaintiffs are going to argue that that's satisfied. Now, the economic test, we don't quite know what the threshold is, but West Virginia v. EPA talked about several $1 billion a year in compliance and abolishing an entire industry. And Biden v. Nebraska was about $400+ billion in student loans. Now, what makes this issue somewhat unique is that Title IX is a spending clause statute. So there's actually a direct impact and the loss of federal funding for states if they don't comply. And you have 21 states that ban biological males from competing in women's sports. States like Montana, for example, have laws saying that students and teachers don't have to use preferred pronouns. And my state, Montana, which is relatively small, receives $500 million a year in federal funds. So you're talking about tens of billions of dollars of federal funding at risk every year across the country. Now, the department's response to comments about the major questions doctrine, they essentially say that West Virginia versus EPA was an extraordinary case, and that doesn't meet the threshold here under Title IX. There they say in the EPA had the EPA had no comparative expertise in making relative policy judgments and had invoked ancillary statutory provisions to enact its regulations. Specifically, they're saying there's nothing unprecedented about these Title IX regulations, and they reflect the department's longstanding expertise on what constitutes sex discrimination, and the department has always had that authority. And they say this is unlike West Virginia v. EPA, where the court characterized the agency action as substantially restructuring the American energy market and transforming the expansion or transformative expansion of agency authority. And they even say, look at our regulatory impact analysis. They actually say that this will save money over the long run, so there's no possible way this has a massive economic impact. A couple comments there. I think it's very interesting that the department's preamble, when it discusses the major questions doctrine, doesn't even mention Biden v. Nebraska. And I think many of the threshold arguments about West Virginia v. EPA are negated by Biden v. Nebraska. And then I also think their arguments about the regulatory impact analysis and the financial burden, they don't even discuss the fact that this is a spending clause case. And to be fair, the courts haven't necessarily grappled with that, but I think it's a major consideration. The next big argument is the Pennhurst line of cases under the spending clause. So as I mentioned, one thing that makes Title IX different from prior major questions cases is that it's a spending clause statute, akin to a contract with the federal government. So the federal government says, here's a bunch of money, but it really isn't free because there are conditions attached. And by accepting this federal funding, every year you agree to do certain things, such as to not discriminate on the basis of sex. So the Pennhurst Doctrine says, well, the federal government can't just surprise states when it comes to the terms of accepting federal funds. You have to be provided notice. And under South Dakota v. Dole, the court says the terms have to be unambiguous. They have to be related to a federal interest in the project. They can't induce states to do things that would themselves be unconstitutional. And they can't be so coercive as to essentially force the state into compulsion. So why does this potentially violate Pennhurst? I think there are three pretty strong arguments that the states are going to have. First, based on the text, history, and tradition of Title IX, there's no way these conditions were clear when the states accepted the money. And it's not good enough for the Department of Education to just say, well, now you're on notice, we've decided these are the terms. Second, the various aspects of the rule, such as forcing students, teachers, and parents to use preferred pronouns, will force recipients to either violate constitutional rights, such as the First Amendment, or risk losing their federal funding. It'll also force and coerce states into adopting a new federal policy that forces them to do all kinds of things, like force girls to accept boys in their restrooms and locker rooms, rearrange athletics. So there's simply no choice but to accept these federal funds or let the states take a giant hole in their state budget. Now, the Biden administration's response in the Department of Education's response in the preamble is predictable. They say this is just a spending clause statute. And if you don't like the terms of the contract, then don't take our money. And to be fair, they point to Supreme Court cases that say that under the spending clause, the government has the latitude to tell recipients what constitutes a violation of Title IX. And then finally, they say, well, you've been put on notice because the statute gives the Department of Education the ability to stop discrimination on the basis of sex and to define what constitutes discrimination. And in fact, Bostock should tell you that that includes gender identity. Mm-hmm. And then I won't take up too much more time, but I want to touch briefly on one additional claim. There are various claims that are made against the department, and I think Kim and Bob both talked about this, for the department not exactly defining what gender identity is. And I think this fits under both the arbitrary and capricious arguments under the Administrative Procedure Act, as well as the void for vagueness arguments. Because it's not just about men becoming women and vice versa, it's many other things. And this may sound absurd, but if a student says their gender identity is that they're a dinosaur and this will only be addressed by dinosaur pronouns, is that gender identity? I've seen one list that says there are 107 genders. And with something so subjective, the administration didn't even bother to tackle what really is a core problem with the entire concept of gender identity. Now, this is particularly interesting in light of the fact of something I just talked about, that the department claims it has the expertise on how to define sex discrimination. So in essence, they're saying, you'll know it when we see it. Now, as I mentioned, there were a tidal wave of lawsuits against the new rule, and it's probably the most lawsuits I've seen against something since the OSHA vaccine mandate. And in that case, everyone was trying to win the circuit lottery. And so a special shout out to our friend and former colleague, Candace Jackson, who did a lot of the math on this. But as of last night, we've had 7 lawsuits filed in 7 different federal courts, covering 5 appellate circuits in the 5th, 6th, 8th, and 11th. We have 22 states, 4+ nonprofits, as well as 18 school districts and several private plaintiffs. And I'll give a shameless plug, but also a shout out that my state, Montana, is represented by Bob's organization, the Defense of Freedom Institute, where we've joined with the state of Louisiana, their Department of Education, and 18 school districts, along with Mississippi and Idaho, to file, I think we were the first technically, challenge to the rule, although everybody came in pretty quickly as soon as the rule was published. So that being said, I expect there to be more in the coming days and weeks.
Yeah, I do as well. Thank you, Christian. It's a great recitation. I want to go back quickly to a couple of issues we've not been able to really dig into that merit greater attention, and that is the athletics issue and also the issue of parental rights. With regard to the athletics issue, and I'll just throw this out to the group, there seems to be some real disagreement about what this regulation does with athletics. There's language, it can be read in a number of ways. One could read it to say, yeah, we fully endorse the notion of sex-separated athletics. It's permissible, although we do see it as an undue burden. It is part and parcel of Title IX since the Javits Amendment, the early regulations. And so, yes, states may have sex-separated sports, but left unaddressed in my mind is if trans girls are girls, then they should be considered girls as a sex and be able to participate in a team that aligns with their gender identity. Does that make sense? Is that a concern, or am I reading something that's not there? And when you couple that with the notion that the Justice Department has filed a statement of interest in various cases, and I know of at least one, which is the BPJ v. West Virginia State Board of Education case, which relates to the Save Women's Sports law in West Virginia. It seems to me, and that they have maintained in that statement of interest, and from what I understand, continue to do so, that the West Virginia law violates not only Title IX but the Equal Protection Clause. Should we expect to see a change of litigation position by the Departments of Education and Justice in these cases? So I'll just throw that out for comment.
I'll start, Bob, and then I hope Will and Christian will weigh in as well. But no, I don't think you're wrong, and I don't think that I don't think it's an exaggeration for us to be concerned with how the department is going to enforce the athletics provision of the rule. So, as I mentioned earlier, there is an exception in the final rule that would allow schools to continue operating sex-separate athletic teams. I think the West Virginia case that you pointed out, I think one of the reasons why the Department of Justice has not changed their position that participation based on biological sex in athletics violates the Equal Protection Clause in the Title IX is because I think that is what I think that's what OCR, I think that's what the Department of Education is going to say in the athletics NPRM. So I think this final rule was just a way to kick the can down the road. The final rule that we're talking about today, the sex discrimination rule, includes in the preamble, I think the department specifically says, that categorical prohibitions on participation based on gender identity would not satisfy the requirements of the athletics NPRM. So they're already indicating that that's where they're headed. They're already indicating that that these save women's sports laws that that states across the country have implemented are likely not going to be permissible. So I think it's more of a sign of where the department is headed.
I view it as an election year feint. They don't want to do the square regulation on athletics in 2024, so they're bearing it here, and they're going to enforce it against states that have rules with categorical rules. So I think that it's going to apply to athletics. And, I've made this point a couple of times. I don't know how persuasive it is, but there's nothing in the rule that says schools only have to have boys and girls teams. I mean, a two-spirited student who says, I'm neither male nor female, I can't participate in athletics unless you create a two-spirited team, or an agender person, who says, I don't want to have to compete against males and females. I don't fall into either bucket. So how many teams or bathrooms or locker rooms do schools have to create before
How do you accommodate that student?
Right. So you have to create an equal athletic opportunity for them, right? Or it's gender identity discrimination. And so I don't know if there's a difference between teams. Like if you don't have a team of 9 for baseball, maybe that doesn't work. But if it's an individual sport and this person wants to participate, I don't know why that wouldn't be a violation of this rule, is what I'm saying. If the only way the two-spirited person could play sports is by the school having a separate team, why wouldn't OCR come down on that school under this rule?
Just reading the preamble, I get the sense we've all worked in a governmental agency, particularly this department, and we know that there's not a monolithic opinion within each agency. There are disagreements within offices that need to be reconciled. There are differences between offices that need to be reconciled. There are differences between the secretary's advisors. And once there's a departmental position established, very often there is disagreements with domestic policy council, other units of the White House, executive offices of the president, not to mention other agencies, not the least of which is the Justice Department. And as I read through this preamble, I sense that there is that some, perhaps not on the ultimate goal, but on how to get there. And so you've got this, as we'll put it, sort of this election year feint where they were sort of, do the nod in favor of gender identity protections, but seek to live another day politically on the issue until after the election. That's just how I see it. And I think at the end of the day, sex-separated sports based on biology, under this administration are at the end of the day will be, discouraged, let's put it that way, if not abrogated, ultimately. Let's talk about parental rights. We have a few more minutes. This is an issue that has got parents' rights groups up in arms. They are paying attention to this regulation. They're fired up about it. You've got at least one parents group that I know about that has filed a lawsuit in the 11th Circuit. How does this? Why is this rule causing such concern amongst parental rights groups?
Give
Well,
me-
obviously,
yeah, no, go ahead, Will. I went first last time. Go.
I'll turn it over to you. Obviously, the provision about gender identity discrimination is a sign to schools that they better be careful. And it'd be a shame if they were investigated by the federal government and lost their federal funds. So if students start transitioning and there's a fear that even telling the parents counts as discrimination, because Title IX says it's illegal to subject students to discrimination, that they'll say, let's play it safe and not tell anyone. Because we definitely have a federal duty above all state duties, so let's just abide by that one. So I think there's a legitimate fear by parental rights groups that whether or not the reg says, hey, keep it secret, that will be the reaction that schools have.
And go ahead.
Let me just add on to that, Bob, if I can. So
Please.
I think, one of the things that I would point to that was in the final rule, there was language included where the department said something like, nothing in these final rules prevents a school from sharing information with parents. And I think what parents really wanted to see, what parents really needed to see because of the level of distrust is something saying, no, the schools have an obligation to share information with parents. And it seems like the department, just like on the gender identity, sexual orientation, seems like they're trying to kind of straddle the fence on the parental issue too. We know of cases across the country where schools have kept information about transitioning students from parents. We know that they have duplicate files, an education record under FERPA, and then a medical file with everything else that they don't want parents to know. So we know that there are, we know that some of this activity is going on. And I think that parents really wanted to see a strong statement here that they had a right to access information, and they just did not get that from the department.
For sure.
I would add, the folks that have been litigating the parental rights cases for the last few years, particularly, and I can think of a First Circuit case where parents have sued a school district for transitioning a child without their permission. And as they, allege these constitutional claims, particularly in the one case I'm thinking of in Massachusetts, one of the things the court looked to relieve the school district of liability was a generic human rights law from the state of Massachusetts, even though it may not have specifically said you can hide a gender identity from parents. The court said, well, it's close enough. And at least because the school district was trying to comply with Massachusetts law, then we're not going to hold the school district responsible. And now you have a federal rule that essentially blesses a lot of this conduct, even implicitly. And so this is another excuse for bad actors to take parental rights away. And I think that there's a lot of worry in the community that this is only going to exacerbate what we've seen over the last few years.
Yeah, in connection with the FERPA issue, we should explain that for those who aren't involved in this area, that FERPA provides parents the right to inspect their children's education records upon request and to copy them. What happens is when they make these requests, the school, as you said, Kim, will often classify the records relating to gender identity affirmation or counseling as a medical record, so they don't have to produce it. The parent will then file a complaint with the U.S. Department of Education, which is charged by Congress with administering FERPA, investigating FERPA complaints. That is an overburdened agency in that regard. They have thousands of complaints. They have some that have been open for several years. And the parent is then left with a federal agency that also administers Title IX to answer its questions regarding, or its, to deal with its complaint regarding FERPA rights in the context of gender identity affirmation in counseling. And of course, what will happen is that there will be coordination between the two offices within Ed and a response provided depending on whoever is running the department at the time. I would actually look for this administration or a future administration to do some regulatory work under FERPA to clarify this issue, to either degrade or burnish parental rights in this regard, and clarify that these are in fact education records. And just so everyone knows, I have been monitoring for questions, and I've been asking questions and clarifying based on sort of the input we've been receiving in the chat. We have one question I think that we've not yet addressed. We only have a few more minutes, and that's the following. If the courts invalidate only a portion of the rule, such as that regarding the definition of sex and extending that to gender identity, would the whole rule fall as a result, or will the due process and harassment related provisions survive? What's your thinking on that, Will, Christian, Kim? Just throw it out there.
I think courts are reluctant to overstate their rulings right now, especially when it comes to facial challenges. So if the court can say, well, I can sever the change to the due process measures with the gender identity thing, I will.
Agreed.
Yeah, I agree. I do think there's a possibility that there could be sort of a combination of claims, so that they can square the circle in the sense of if they do, invalidate the gender identity portion or expanding the definition of sex, perhaps there are other arbitrary and capricious claims that don't fit really well with the rest of the rule that a court would look at and say, well, that's sort of the excuse for getting rid of these other 4 provisions that don't now fit within the rule. But it's really anyone's guess. But I tend to agree with Will that the due process protections in particular are so separate from other aspects of the rule that a court's going to be hesitant to specifically strike those down just because of the gender identity portions.
And I think it's a certainty that a future administration would change those, in the future. That's a definite. We only have about a minute left. Let me turn to each of you for some very quick closing thoughts on the rule, the pending litigation. Kim, we'll start with you.
Yeah, well, I just want to say thanks again to the Federalist Society and to Bob, you and Christian and Will for hosting this. I think this has been a great discussion. I think one of the things that we have been communicating to schools, and I know a lot of states have told their schools, do not take steps to comply with this rule. And we've communicated our legal concerns with that, with the final rule. And, I think that we just have a long road ahead before we get resolution on what's actually going to happen here. And I know that there's a lot of people coordinating. There's a lot of people involved in the fight. So just look forward to doing everything that we can to make sure that all students are protected and that the rights of women and girls are preserved under Title IX.
Christian?
Yeah, well, thanks again to the Federalist Society. Thanks to everybody. Great to be here. I think that when you take everything in the totality, when you look at less due process protections, a lower standard for sexual harassment, a lower standard of liability, and then more categories covered under the definition in this sort of vague, nebulous way where we don't know, like I said, we don't know it until OCR tells you, it really creates an environment for schools that is, one, just a difficult regulatory regime to navigate, but one that I think is going to really cause a deterioration of what's happening on college campuses, as if things weren't already bad enough.
And I'll just close by saying, look, the 2020 rule is in place. We have a stabilized equilibrium right now. It survived legal challenges. And now we're upsetting the equilibrium. So, we don't know whether this rule will actually ever be effective or not. So I completely concur with Kim's comments about it's not clear whether schools need to start complying with this. Definitely far from over. And so, the proof will be in the pudding. But you can see that we still call the 2020 rule the current rule until further notice.
Great point.
Perfect. Well, guys, thank you. It's good to see you again. Thanks for a great webinar. Steve, I'll hand it to you.
Thank you. Well, thank you for this great panel and this outstanding conversation. And thanks to the audience for joining us today. For more programming on the regulatory state and its impact on the American way of life, please visit regproject.org. That is regproject.org. Thank you.